everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody to hit the like, share, and subscribe button for me. Appreciate everybody's support. There's a PayPal link down there for anybody that wants to share some love. Every little bit is appreciated. And the StreamYard link is there for anybody that wants to join the panel. We're going to go over enforcement of surety bonds, part 2. This is the second video we're going to watch, extending from last week on how do we enforce these instruments. So we'll get right into it.
Welcome to the Probate Nation. My name is Richard Ruddy. As we have learned over the course of many shows, persons appointed as fiduciaries in an estate, testamentary trust, conservatorship, or for the property of a minor child all have to be bonded. In some appointments, the bond might be without surety, essentially a personal bond. In other appointments, however, the bond must have surety, and this means an insurance company must be involved. In part 1 on enforcement of surety bonds, we learned that many of those.
And he's saying that a surety bond must, an insurance company must be involved. And this is why we're looking at the concept of collateralizing their surety bond / fidelity bond, whatever they have, with an indemnification bond with the same insurance company that is holding that bond.
Those fiduciaries must have a surety.
They are literally the brokers.
Bond. And to get that surety bond, the fiduciary must agree to provide an indemnity agreement to the surety. We touched on a couple of the key provisions in the typical indemnity agreement in part 1.
Provide an indemnity agreement to the surety. So this is part of the problem about being recognized in these administrative courts and these financial transactions in the proper capacity, is that as a third-party benefactor, there's a qualifying set of documents we can produce and surrender to the proper authorities for proper certification to qualify the indemnification as a third-party benefactor to be recognized as such. Otherwise, the presumption is through that legal fiction. And until we break that or pierce that corporate veil is going to continue to clothe us. It's going to continue to cover us under insurance.
1 as well. Tonight we will complete the discussion of enforcement of surety bonds. And during this program, we will look at other key indemnity agreement provisions, learn how and when the surety gets involved and undertakes to enforce the indemnity agreement against the fiduciary, the liability exposure of the fiduciary when there is a bond forfeiture judgment.
And that's one of them funny terms I like to point out, undertakes. When you undertake to do the underwriting and don't do the underwriting or overwriting, line item vetoing and stuff according to whatever capacity you're in, and then just give a blank endorsement, you just lost everything. You just gave it all up.
And much more. We are pleased to have returning as our guests 2 attorneys who represent insurance companies that issue surety bonds. They will serve again as our guides as we conclude our discussion on the enforcement of surety bonds. Our first guest is a partner in the national law firm of Watt, Teeter, Hoffer, and Fitzgerald, located in its McLean, Virginia.
And this is an important aspect for those that do have qualifications for some kind of license or anything. You don't have to have insurance. You can actually go get a surety bond, say a traveler's surety bond, in that driver's license name to cover you for traveling. And that makes a distinction in that surety bond that you're willing to take on the surety for the proper capacity, so long as it's understood. You're indemnifying indemnification clauses and whatever else other clauses you might need to put in there, according again to the capacity. If you're actually driving in a commercial capacity, it would be something different, but you could still use your own private surety.
Virginia office. Her practice focuses on creditor rights and bankruptcy, including probate surety bonds such as administrator, executor, conservator, and guardian bonds. She is a board member of the Maryland Bankruptcy Bar Association and an active.
Did you hear that? The probate courts?
Her practice focuses on creditor rights and bankruptcy, including probate surety bonds such as administrator, executor, conservator, and guardian bonds.
Administrator, executor, conservator, guardian, surety bonds.
He's a board member of the Maryland Bankruptcy Bar Association and an active member of the American Bankruptcy Institute, the Northern Virginia Bankruptcy Bar Association, the Walter Chandler Inns of Court, and the International Women's Insolvency and Restructuring Confederation. She has written and presented on various creditor rights, bankruptcy, and surety issues. Our second guest is also a partner with Watt, Teeter, Hoffer, and Fitzgerald, and she is located in its Boston office. Her practice focuses on surety, construction, and insurance coverage. Her surety practice has a particular emphasis on commercial surety bonds, which includes all probate bonds. She is an active member.
Commercial surety bonds, which includes all probate bonds. This is what they're doing in those administrative courts. It's a probate station. Probate capacity. A decedent record. The individual's name and number identify the record. And it's just a personal effect of the estate, which is still yours. They're just administrating it because you haven't come forth and declared your estate in the proper capacity.
In the American Bar Association's Tort Trial and Insurance Practice section, and is a vice chair of the.
And that would be, in an ecclesiastical sense, a legacy birthright heir.
Its Fidelity and Surety Law Committee. She has written and presented extensively on various surety issues and is the author of a chapter in the ABA FSLC book entitled Probate Bonds. Please welcome attorneys Marguerite Duval and Sharkrisha DiBartolo. Ladies, welcome. I'm telling you, every time I read that introduction, I think, my goodness gracious, I'm lucky to have you guys as my guest. All that
Absolutely.
brain power. So Sharkrisha, one of the things that we talked about in the first show, we really got into the application process to obtain a surety bond, and then we started to get into the indemnity agreement itself.
And again, this is from Probate Nation, just so we get that out there. Probate Nation, 432 subscribers now.
And talked a little bit about that. So let's go back again. Let's continue with the indemnity agreement. Let's talk about some of these key provisions that the surety can use to protect itself and recover its losses. So can you explain the importance and relevance of the provision of the indemnity agreement that allows the surety the right to settle or compromise any loss that occurs?
Certainly, Richard. And thank you again for having us back a second time.
Oh, of course.
Settle or compromise. That's C-O-M, promise. That's with promise. So you can settle it, or you can defer it, the debt. You can settle the debt, or you can defer it with a promise to pay in the future at a set date and time a certain sum.
So that provision essentially gives the surety broad authority to settle claims that are made against the bond. And it's there because...
See, the claim is made against the bond. It's not made against you. The claim is made against the bond. They reiterate this time and time again. They are making claims against the record, the documentation, the bonding, the certification, the testimony.
Sometimes things happen. The fiduciaries can disappear. They may die in the course of the administration of an estate, or they may stop cooperating with either the commissioner or with the surety. So there's a provision in the indemnity agreement that gives the surety the broad right to pay, adjust, settle, or compromise claims. There is
pay, adjust, settle, or compromise. So now we have four ways. We can pay it, we can adjust it, we can settle it, or we can compromise it.
While the surety and the fiduciary have a similar interest, no one wants to see the bond called or money paid out under the bond. Sometimes positions are taken by a fiduciary that are either not justified under the law, or that sometimes fiduciaries may even just give up and stop participating in the process. And so the surety needs to have a way to be able to resolve claims, and this provision allows them to do it. There's also a second part to the provision that
this goes along with trust law, in that a trust shall not fail for want of trustee, saying that the beneficiary who has been named as surety needs to dismiss the trustee. The fiduciary who is not acting in his proper capacity, he can do so and settle the claim himself. It parallels it. It mimics it perfectly. It's just a different language. It's doing the same thing.
That's also very important, and that provides that evidence of fetus by the surety is prima facie evidence of the fact and extent of the indemnitor's liability to the surety. And that means that if the surety were to bring a claim against the indemnitor and present to the court the evidence that it's paid the claims, then it satisfies its burden of proof with respect to the extent of the indemnitor's liability to it and the fact that the indemnitor is liable to it. So it's a very important provision in the agreement from the surety's perspective.
Okay. Now, let's continue on. Marguerite, I'm going to ask you, can you explain the importance of the provision that gives the surety the right to require the fiduciary to place funds, basically to pay over funds to the surety even before there's any loss?
Right. Yes. So quite simply, once the
Understand what he just said there. Pay over funds to the surety even before there's any loss. Remember what we talked about, prepaid expenses. Again, they're telling you it's prepaid expenses. If it's prepaid, then why do you need to defer the debt?
claim is made on the bond, and that is basically when sort of the Commissioner of Accounts of the court issues a show cause order to pull in the fiduciary.
And again, if there's equal consideration, equal benefit, then there's prepayment on both sides. You're paying each other prior. That's what the negotiations are actually about. And if you know what you're doing, you end up using a credit system and everybody's made whole right at the settlement, the financing, finance to settle. So if I'm financing it to begin with, at the beginning, see, you don't finance things after it's done. You finance it at the beginning. That's prepaid. If it's prepaid through financing, then that's to put an end to settle. Look it up. Finance etymology, to settle, to put an end to put an end to what? The debt. You don't defer its payment.
Or the surety, or sometimes it could be a simple notice of a hearing. Once a claim is made, depending on what is really at issue in that claim, the surety has the right to then turn to its principal, it's the fiduciary of the estate, and say, a claim is made for $10,000. It looks like that's gone missing, or you haven't accounted for that property. There might be a loss on the bond, and so that the surety doesn't have to afterwards chase down the fiduciary, the principal, for those funds if there is a loss. It's sometimes easier to ask for things up front before people spend their money.
And see, if the record shows that we're the ones that took on the liability as a surety, and we do a forensic a securities accounting on that, find out that there was a conversion of some sort and that we weren't paid what we were due, then that itself voids the fact that they're even demanding payment. Again, that finance. What financed this? Ask them, what financed this? And they're going to try to come up with an answer and say, well, it was financed here. Oh, so you're saying it was already settled. They're the ones using the twisted language. Untwist it and use it against them. Understand how it works and don't let them trap you anymore.
The surety might send out a letter or demand, should I say, and say, there looks to be a loss of $10,000. We are demanding that you post with us cash of $10,000. If the claim is only $5,000, then the surety, and I say if the loss under the indemnity agreement is only $5,000, then whatever's left over will be returned to the fiduciary. If, however, it exceeds the $10,000 demand, the surety can still try to get reimbursement or be paid back from the principal for anything over that. But the idea is that the surety doesn't want to have to be out of pocket if there looks to be a loss. And the best person to make sure that doesn't happen is the person who's primarily responsible for all this, and that is our fiduciary.
So yeah, so if you get a letter like that from a surety company asking you to put up some money all of a sudden, I would think that would get their attention, that maybe they ought to get on the stick and fix whatever the problem is. So Shakrisha, can you explain the next provision?
See, and that's what that forensic securities audit and the indemnification bond should do. It should activate them to get them to do their job. Oh, something's wrong here. That's all we're looking at. It's not, again, they're going to the record in all these cases, so point out what's wrong in the record so they can notice it, and they will surely notice it.
I want to focus on is this provision that authorizes the surety to investigate statements, obtain credit reports, and so on. Tell me about this provision and how that relates to the indemnity agreement.
Sure. Well, I think one of the parts that's probably most important for your viewers in this section is the fact that the indemnity agreement gives the surety the right to obtain credit report information. And it does that for a couple of reasons. One is it's, and the surety can do that really at any point in the process, during the application process, during enforcement.
So when it comes to like the Freedom of Information Act request for city budgets and stuff, there's certain information you can get. But when you're talking about having an actual surety indemnification bond somewhere with them, they're now liable to hand over those records as far as the credit reports, so you can determine whether they're in good standing to be able to extend credit to them. See, that's the whole operation. That credit report, I've asked many times, well, where's the debit report? If there's a credit report, what's balancing it? Don't you think it would be a debit report? It doesn't make sense.
Of the indemnity agreement, and it gives the surety both information. It's like when you apply for a loan for a car.
They most certainly have access to your credit. You should be able to have access to their credit as a corporate charter,
For a credit card. It allows
a public corporate charter.
the surety to see what your financial stability is, and needs to know that both when it's issuing the bond. It also would want to see that information if it needed to proceed under the indemnity agreement, and the indemnity agreement gives it the power to be able to do that.
Okay. Now, is there a provision in the indemnity agreement that somehow where the fiduciary can acquire, where the fiduciary has to give the surety some sort of security interest or lien? And what is that? How does that work? Or
Well, that's a provision that's also in the indemnity agreement, and it's automatic from the standpoint of when the application and the indemnity agreement is signed. It gives the surety
It's automatic. So it's the equal consideration, equal benefit kicking in automatically.
a security interest in the fiduciary's title or right proceeds to any insurance policy. That can come into play, for example, if one of the fiduciaries is an attorney and there's a claim of negligence against the attorney that could trigger a malpractice policy, for example. The surety has a security interest from the outset in any proceeds of that policy, for example.
now, I'm just curious though, do the bonding?
So again, see, they're not going against the attorney, they're going against the policy. And what happens is the policy will pay out a certain sum, and if you have a claim greater than that, then you can go after the personal assets of the attorney or whoever you're going after, because it didn't fulfill the claim to make you whole.
Companies normally,
And of course, you're only allowed to go after it to a certain extent. This isn't something you go after a bum for something because he's never had anything, he's not gonna have anything, and on the precept that he might, then you can still take a certain sum if he happens to supersede it. So be it, but that's not a likely bet. So it's when you're going up against these people that are in these upper class sectors that it's really going to impact, and that's why this is so important. Our community leaders are such people, and they're the ones that are abusing this stuff and allowing others under their helm to do the same. It's called covering your own ass. You have to learn how to do it. They're doing it. You just have to learn you have a bigger ass and a better ass to protect and a better way to protect it, and that's through the knowledge of being that very one you're supposed to be, a leader. We're supposed to be leading our public officials.
file UCC-1s to actually record that security interest?
They can. I have to be honest, I haven't seen one in the probate context. I've certainly seen it in contract surety.
Of course.
Marguerite, I think, may have some experience with that in this context, but it's definitely something that can happen, especially if you have an
In contract surety. So again, we're talking about private surety and contract surety. That's that traveler's surety bond as opposed to driving insurance. They are distinctly different.
estate with considerable value. So the surety would want to have that interest recorded early on, so it's
Sure.
not something that comes up later where they haven't perfected that interest.
Of course, of course. Marguerite, I'm going to turn to you as we go to the next topic, which is where the surety gets involved. So when exactly does
So we see it's a matter of perfecting the interest first before you go slamming shit into some kind of trust or something like that. We're talking about an estate issue, and an estate is all real and personal effects encompass the entire estate. That's all property, that's whether it's in a trust or not. So it's a matter of establishing your estate matters first.
surety get involved in an estate or conservatorship?
So we're going to go with when we typically get involved. I mean, things change from case to case, and so it just depends. But oftentimes what happens is we will receive a show cause order for why the fiduciary shouldn't be removed as a fiduciary and why the bond shouldn't be forfeited. Sometimes we get notice earlier on where, particularly if
See, this is where we have people trying to recuse judges, not understanding what's going on. If you're coming in as a surety, you don't recuse the judge. You hold him to his fiduciary capacity through that indemnification surety bond by recognizing what's going on in those courts. You do it outside of the courts preemptively, and again, by establishing the estate. That's the correction of the record. They're trying to administrate an estate in probate. The only thing that needs to be done to establish the estate is the living will, and that's an expression of a trust itself. So it's just, again, a matter of recognizing what the estate is and how to stand on your feet on it. Let them hear your yea is your yea and your nay is your nay.
let's say in Fairfax,
Study to shew thyself worthy approved, of course.
the commissioner of council hold more informal hearings, well, not informal, but will hold formal hearings, not at the court level, but the commissioner level, and they'll notice the surety. And depending on what's going on, the surety might send an internal claims representative to that, or they might hire outside counsel. Just again, depending on the reason for why the commissioner is holding the hearing, but once it goes to a show cause order, then the attorneys will get involved because we have to represent the surety in court. The surety can't just send, someone from their claims office down. They have to be represented by counsel in court. And
they have to be represented by counsel in court. That's false. There are different courts where we can bring these issues as a matter of equity, okay? And that doesn't involve attorneys. So the one she's talking about here is the corporate surety, not the private surety.
That generally means that the principal or fiduciary hasn't been doing what they're supposed to be doing, or there's funds missing, and there's legitimate concern that something is awry.
Sure. And I will say that certainly many of the commissioner's office, and certainly in Fairfax,
and that's the deal with this dismissal with the failure to appear case. See, I did a couple videos exposing that particular case and for what was in the record at the time, and how it had zero finances, no charges, no bond was found, no long title, zero evidence of anything. And yet this Andrea Dreyer, this judicial officer Dreyer Andrea, felt the need to issue a bond or order a bond to be issued. So she ordered the bond, the clerk issued it, the sheriff picked it up, never was able to serve it. And then, of course, they said they attempted diligent service. And of course, that shows that they didn't have service. There was no one to receive it for receiver or anything. So we went through this thing about dismissal a couple times. And then they sent me a notice that said costs are taxed to the defendant. And when I look up the case, there's $96.06 as a cost. But the document says taxed. So in my enlightened confusion, it must be a tax issue. So I'm going to have the IRS do a forensic securities audit on it, because I'm not so secure in the definitions. Know what I mean? I'm not so secure in when this was financed, how it was financed. The judge ordered it, so he must have come to some settled determination in his mind as to what the facts were, or else they're just still pushing a presumption. $14,409, what's that? We'll take a look, but let's get back to the video real quick, and I'll look that up.
the commissioner's office is very proactive in the sense that they will write letters and they will listen to what you have to say. If you got a good reason why you haven't done something, they'll certainly give you time to get stuff fixed. But at some point they reach the limit of what they can do and they have to move the ball. And that's where you then get those show cause notices, which is not a good thing. And now the court's involved. So please be responsive to those. Sure, Carisha, let's take a look now. Is there a progression of involvement by the surety? I mean, I know Marguerite kind of talked a little bit about that, but maybe you could fill that out a little bit more.
Sure, Richard. Well, typically, it kind of depends on what's happening with the estate. If it's something like an inventory hasn't been filed and the surety gets notice of that, and there's no need for the surety to actually appear in court, you may just get someone from their claims department writing to the principal to say, hey, we've got this notice, your inventory is late, or your yearly accounting hasn't been filed, what's going on? And so you might just have that kind of involvement from the surety at the claims level and not with an attorney right away. And of course,
And see, again, that's referencing to a corporate bond, corporate surety bond, because they're asking for business records. So if you're not running a business, you can still be a surety for the legal entity that is not organized and provide an indemnification agreement so that when they try to attack you in those corporate Article 1 for courts, then you can show that you're not qualified to appear in those courts in such a fashion. But you do have an indemnification agreement in case they can bring that very same claim to you on the private side. If they can't, oops, sorry, you made a mistake. Here's my fee. You can't force me into labor. You can't threaten to use or abuse the legal system, legal or lawful system, criminal, civil, or administrative for a purpose which it wasn't intended. And that's for corporate purposes. I'm not a corporation.
if you got correspondence like that from the surety saying, hey, what's going on? Why haven't you filed these things? You should respond to that right away and see if you can get it fixed, and let the surety know that you're on top of it and that you're taking care of it. Because if you don't, and then you get something like a show cause hearing, that's when the surety's involvement will get more significant. They might have to go and hire an attorney. And that's when the costs start to add up that the surety is going to start looking to the fiduciary to compensate it for. So yeah, so it can vary.
See, I'm telling you, you have the capacity to do so if you understand what that surety is by providing that. That's why when they go to court with that birth certificate, that's the presentation they're trying to make. But that's not where you make that presentation with the birth certificate. The birth certificate is a certificate that needs to be certified with its amended documentation for its use. See, it's a bond that can be used in several ways. You can use it as an international bill of exchange. You can use it as a promissory note. You can use it as a surety bond. You can placate that there's already a surety already set and use the copy that you have as an indemnification to match up with it. All kinds of ways you can use it.
It starts at the same level, and then depending on the severity of what's happening and whether or not you need to be the surety needs to be represented in court, then it might actually go out and hire counsel.
Okay. Well, let's turn now to the surety's rights and remedies and this is really important. So, Shakri, let me start with you again. Review for us the key rights the surety has against the fiduciary, if you would, please.
Sure. I mean, the primary and key right is that the surety has the right and the discretion to act, including settling claims and investigating claims. And
settling claims and investigating claims. He certainly has that right.
Go out and hire counsel.
Okay. Well, let's turn now to the surety's rights and remedies and this is really important. So, Shakri, let me start with you again. Review for us the key rights the surety has against the fiduciary, if you would, please.
Sure. I mean, the primary and key right is that the surety has the right and the discretion to act, including settling claims and investigating claims.
Right and discretion. So again, if you want to believe that you have rights, then you have to have a certain experience, knowledge, wisdom, whatever, to be able to have the discretion to then turn around and settle the matters in whatever fashion you need to, whether that be indemnification or whatever. If you want to contract the court into a commercial capacity, you can certainly do that as well. It's a matter of how you negotiate. These are all negotiable instruments. And I could see certainly that taking a birth certificate into a courtroom could be the establishment of a salvage process in handing it or surrendering it over to the United States as a claim on for an award for salvaging a vessel of the United States from abuse or threatened abuse of the law or legal system.
And once it does that, it has the right to indemnity from its principal for the cost of anything that it incurs. And one of the important things about that discretion is that in almost all jurisdictions, as long as the surety acts in good faith in responding both to the claim from the standpoint of the cost it incurs, as well as what it pays, if it pays anything to resolve a claim, most jurisdictions will say as long as the surety acted in good faith, it has the right to recover what it paid, its costs, its attorney's fees, everything from the indemnitor. So that's a very important right, and it's upheld in almost all jurisdictions.
In good faith. So again, it's a matter of simply knowing right and wrong and going forth in good faith that you are doing what's right. If I did wrong, please explain to me what I did wrong and allow me to ask questions for clarification and resolve. That's good faith. Negotiations. I'm not here to make any false claims. I don't expect anybody else to make false claims either. I'm operating in good faith.
Now, is the standard of good faith hard to meet for a surety?
No, it's not. And actually, it's really it's almost the other way around. An indemnitor really has to show that the surety has acted in bad faith or somehow in collusion with the parties that they've paid in order to get out of paying the surety back.
That they had a very willful or negligent intent. So again, forgive them for they know not what they do. They don't have that intent. They're not doing it on purpose. Many of them are not doing it on purpose. There are some, I'll agree. But we have to understand, we have to learn how to treat them differently first to find that out. You can't just go around treating everybody as if though they're already criminals. That's Hitler's willing executioners, for crying out loud. Learn how to act in good faith and have faith that your brother is acting in good faith.
Under one of these indemnity agreements.
Okay. Now, Marguerite, what are the consequences of a judgment for forfeiture of the surety bond?
Well, in Virginia, Richard, when the bond is forfeited, the judgment is entered jointly and severally against the bond principal or fiduciary and the surety. And ideally, the surety would love it if our bond principal paid that judgment.
And in this case, when you get that birth certificate with the birthright legacy heir, to have it as holder in due course so you can settle the matters and surrender it to the United States, who is the principal, and the surety is the state that ceded their jurisdiction to that principal to oversee and administrate the trust of the public as a public service. It seems logical and reasonable to me. Salvation, salvage.
But more often than not, the courts in the states or the conservatorships look to the surety to make that payment. And when the judgment is entered jointly and severally, there's actually a Virginia Code statute, Virginia Code section 49-27, that grants the surety very simply a judgment then against the bond principal for the amount that is.
Automatically grants the judgment. Do you understand that?
Paying the surety back under one of these indemnity agreements.
Okay. Now, Marguerite, what are the consequences of a judgment for forfeiture of the surety bond?
Well, in Virginia, Richard, when the bond is forfeited, the judgment is entered jointly and severally against the bond principal or fiduciary and the surety. And ideally, the surety would love it if our bond principal paid that judgment, but more often than not, the courts in the states or the conservatorships look to the surety to make that payment. And when the judgment is entered jointly and severally, there's actually a Virginia Code statute, Virginia Code section 49-27, that grants the surety very simply a judgment then against the bond principal for the amount that is paid, plus
by statute, it automatically grants the judgment.
A 5% statutory penalty. So once the surety pays, we get, let's say, for example, bond forfeiture is $100,000. If the surety pays that, then there is, by statute, the surety can move by motion. It's often all done in one order, though. By statute, we get the $100,000 judgment against the bond principal plus a 5% penalty. That's $105,000. And then we get post-judgment interest. And that's important for people to know that that's 6% per annum by statute. So that those numbers can add up very quickly if you're not careful. In addition, this by statute, it provides for an assignment of the original judgment to the surety. So the estate has a separate, or the conservatorship has a separate judgment against the bond principal. And once the surety pays, that by statute gets assigned to the surety. Again, all this is generally taken care of in one order for bond forfeiture versus going through the steps, which is better for everyone because it just means less fees and court involvement. It takes care of it at the same time.
Less fees and court involvement. See, they're telling you this doesn't involve court. Or it takes less court involvement. Why do you want to keep going to those courts? Don't you want to do this in private? Isn't that the issue? Everybody's making your privacy a public issue in the public courts. Yet that's where everybody wants to go and scream their story and cry wolf or whatever it is they want to cry. You got to stop it.
But sometimes they do have to come. The surety will have to expend additional resources once they've paid to come in. So I know you haven't asked me yet, but I would say at this point, my comment is if you know you're going to be facing bond forfeiture and you can't pay, my recommendation is to avoid continuing accrued attorney's fees by the surety is just to make sure that everyone gets taken care of in one big order, because
in one big order, because if you don't want to pay this, you don't want to pay that. So let's take a look at that issue about they may have created a security from your birth certificate, but it's their gamble. Much like the pony has no stake in the bet. That's absolutely right. It's a bond at this point. You can securitize it. Now, what's happening is at the state level, they're getting that bond and they're securitizing it through the state's blue sky securities laws, which mimics the federal securities laws. So again, it placates the expenses incidental to transfer of title and getting it to the hands of the United States and registered with the Securities Exchange Commission to get their certification to match it, to give it equal consideration of the value of the bond, so stated in the amended indemnification agreements and clauses. So now they can't use their blue sky securities mimicking process to mimicking any securitizations of your bonds if you're holding that indemnification bond up at the upper level. And again, that expense is incidental to transfer of title to the Postal Service would then carry on the title to the Postal Service, leaving the indemnification agreement with the principal, which is the United States.
these are rights that are there. So whether we get it on Monday or we get it on Friday, it's going to happen.
The principal is the debtor, located in Washington, D.C.
And so sometimes it's worth just being cognizant that, again, the loss includes our attorney's fees, and you don't want to have to pay attorney's fees you don't have to pay.
Sure. I mean, certainly, I advocate that being forthright with.
Yeah, so just go get another one of those bonds and put the value to that to pay it, to pay, settle, compromise, and what else? What was it? I can't remember what the other one was.
With the Commissioner of Accounts Office or with Surety Bond Counsel is to make things go as smoothly as we can, recognize that we have a problem. Let's see how we can fix the problem. Along the way, recognizing as well that we have to protect the rights of somebody who has incurred a loss, which is the surety company. Now, Marguerite, there's this concept called equitable subrogation. Can you explain what that means?
Here we go.
Terms, it means that once the surety pays any portion of its claim, it steps into the shoes of the other party. So, for example, I would say in the context of the estate, if the estate gets a judgment against the bond principal and the surety pays, the surety now steps into the shoes of the estate, whereas it's estate cap is the best way. Like it's basically just if you're now the estate. And if the estate has certain rights because of that debt that has now been paid, the surety, acting essentially as the estate, can then enforce those rights, whether it's against the bond principal or some third party in the sense of recoupment or repayment of that. I think most recently the way I've seen it.
So like I said, it's much like putting on a cape that allows you to be recognized in their courts, or uncovers you to be recognized in their courts. My apologies. Where certain falsities are removed so they can see you for who you truly are, the estate. And they have no authority to administrate you. They already recognize that. You have to recognize it. You are the estate. You and all your real and personal effects, everything you think, everything you say, everything you put in those documents, that's your estate. You extended it beyond what you thought you extended it beyond what you should have, in my opinion, of course, in providing certain data elements to these official documents that allowed a presumption of the legal fiction, rather than making it clear that you're not the legal fiction, you're not incorporating the legal fiction, you're acting as a third-party benefactor. And there's already instrumentalities that are available, but it all gets sidetracked with the enumeration at birth. However, that is actually a remedy. It proves an exception.
Play out is we had money transfer for one estate that was bonded to another estate, and that estate had funds, still had those funds there. And so the surety paid out on the bond and was able to step into the shoes of the estate that it paid the bond for and make a claim to have the return of the funds back, because that
So the guy can have a birth certificate, surrender it to the United States, the principal, hold it against them as that lien that we're saying, you know, granting that surety and all that, so that they can come back against the state to have all those accounts settled. That way the principal will hold the state to its duty, not you. You're holding the principal by his balls. Now the principal has an agreement with the state as a trustee, a surety already. They will pay out that surety and give them any kind of new furthering education they need to keep people in their position so they can keep it running smoothly. And certainly I would think they would penalize anybody and remove them if they needed to. But again, it's up to us to understand how this process works. Nothing triggers that surety unless there's an indemnification. And if there's an indemnification from a third party, that's going to be held against the principal and not the surety.
return of funds was part of why the bond got forfeited. And so the surety was able to essentially net out a zero loss for a portion of the bond forfeiture of that, acting sort of with its state hat on.
Okay, well, Mark, I'm going to continue with you, though, because I think...
Yes, Tribe makes a point there. Court has the power to compel them to produce documents for you to authenticate. Evidentiary hearing, these are subpoenas, which is subpoena ducis tecum. Bring forth the record. There's evidence in, on, and for the record already, and you will see with its inconsistencies, it creates certain impossibilities that need to be rectified or reconciled.
You know, I think if people are listening to the show, they might, if they're not, if they're trying to beat the bond company, so to speak, you know, can a fiduciary who's been bonded with surety, who now has had a bond forfeiture, can they walk away from their obligation by filing bankruptcy?
No. This is, I'm sure anyone heard the beginning introduction. This is actually one area where I get a little excited about, because it's...
This is what I was talking about earlier. If you go after somebody and they don't have anything, it's still not going to affect the surety. You're still going to get that pay. But if you have something greater and they have nothing, you can't go for it. If they do, you can get that extra accordingly to how much they have.
Where I primarily practice. We keep talking about our bond principals as fiduciaries. They are fiduciaries. They're entrusted with assets and funds of another party. And under the bankruptcy code, and it's called section 523A4, there are grounds to deem the debt due to the surety non-dischargeable. That means if you file for a Chapter 7 or a Chapter 13 or a Chapter 11, the surety could say they embezzled funds, they breached their duties as a fiduciary, and that's why this debt arose. So as a result, it should be deemed non-dischargeable, which means it'll stick with you. You
understand that? This is the importance of understanding what that record says, and patterns of practice, and reasonability. There comes a time that you have to understand 94 cases where somebody's converted something and all of a sudden you say, aha, but you have to spend 8 years to figure it out. You better be prepared to do that investigation, because that's what you're doing. Investigate, that's it. Pay, settle, investigate, or compromise. And I'm going to investigate. That's what I've been doing for 8 years. Now I'm getting ready to move forth, and after I've studied to shew myself worthy and proved, I'm going forth with this cost tax to the defendant, showing all 94 cases with that same conversion. They were all tax issues in a probate court, which is a corporate suretyship.
There are also other provisions. 523A6 involves intentional injury to property of another. So if for some reason the fiduciary here purposely did something that caused damage to property, and again, we talked about equitable subrogation, if we stepped into the shoes of the estate and the estate's property has been damaged, we could seek to find it deemed non-dischargeable forever in existence as a result. And then there's a provision under 523A2 that talks about the statements that you made to the surety in order to get the bond issued in the first place. And I know we touched briefly on some sort of questions that are asked when you fill out that bond application, and it's important that you were...
And that's one of the things I was pointing out to Steve. I was hoping he'd show up, but I'm going to have to give him a call and find out if he's okay. It's been a few since I've heard from him. But it's important to understand the difference between executor and administrator of these estates. That's what she's talking about here when you step under the hat of the estate. You have to be able to execute the estate. That means you have to be able to draw, draft up, and sign documentation. You have to understand your capacity in that signature, how to support it for its varying different capacities, however you use it, all this kind of stuff. You have to understand contract law, trust law, and it's very important to get to doing your research so we know this stuff. This is the stuff that's been withheld from a very knowledgeable and wise people if they would be allowed to expand upon that. But again, coming down to that comfort and convenience, a lot of people just give that up. So it's not just the government and its overbearing supposed authority, but the willingness of the people to be subservient to such a fake fucking king.
Asking is akin to asking for credit. And so if you lie in obtaining credit and you lie in your bond application, another aspect, even if the debt itself may not have been, let's say, the loss incurred by the estate, but the attorney's fees portion or something like that, all that is caused by your lie to the surety company. The surety company could also come after you that way. So there's a couple different avenues under Section 523 of the Bankruptcy Code to.
So if they come to find out that you're not a resident, in fact, and that you're not a United States business, in fact, and that it was only a presumption and that you're the one that said that, and they took you for your word. Man is bound by his word. And you're the one that claimed you were a resident. They didn't. You did. Based on another false presumption, Mom claimed you were a resident. Of course, they're all presumptions. What is a legal fiction? A presumption of the facts presented to the court that stand until otherwise proven. Or otherwise rebutted properly, excuse me.
Deem the debt owed to the surety or the surety acting as the estate.
The debt owed to the surety. See, if the debt is owed to the surety, who is the debtor? The principal. That's who the surety's paying the debt for, the principal. And he's paying it to the third party who has a valid claim. So long as it's indemnified, you got to have that equal consideration, equal benefit. So, and that's the separation and piercing of the veil, of the corporate veil. You're going to disclose that you're not acting in that same corporate capacity, that you're a third party. And therefore your actions are to be taken distinctly private.
Non-dischargeable, which I think most people think of student loans as being non-dischargeable. And I would say there's a few things certain in life, death, taxes, and debt, or student loans. And in this instance, the 523 Acts kind of make the surety debt a lot like student loans. You're stuck with them.
Well, that's very interesting, Marguerite. Now I want to go ahead and turn, but we got just a little bit of time left. I want to get your closing comments from each of you, this advice, practical suggestions, and so on that you might want to share as we've now finished the second show in this process. So, Shakrisha, I'm going to go to you first.
Okay, thank you, Richard.
You're welcome.
I would just say, don't ignore the surety. The surety is not your enemy, but it has significant power under the indemnity agreement.
And again, that surety is the bond that they give you, that birth certificate. It's known as a surety. It just needs other documentation to go with it as a negotiable instrument. Again, that's that salvage process. United States vessel. It's a United States vessel. It's supposedly evidence of the United States citizen, which is United States business. It's a business instrumentality. It's a commercial instrument. Learn how to play it.
Both to resolve issues and to come after you if it has to pay for something. So stay up to date with what you need to provide to the court. Don't ignore the surety. Provide it the information.
Come after you if it has to pay something. They're going to come after you if it has to pay something. Understand the language
that it's asking for, and hopefully you can work through the issues both to your benefit and the surety's.
Marguerite, how about yourself? What would you like to share?
Well, I think Shakrisha stole my thoughts out of my head. I was going to say the exact same thing. I mean, if you get a notice from the commissioner, or you get a notice from the court, or you get a notice from the surety, or you get a notice from an attorney representing the surety, get back to us, get back to them, because it has a snowballing effect. And if you need help, hire an attorney, hire an accountant. A lot of the issues we see can be avoided from the beginning. Again, we see some very simple forfeitures that should never happen. For example, people just don't keep documentation of an expense that they made, and those numbers add up, and or they fail to file an accounting and don't do that. And we didn't get into it, but the success of there are additional costs that happen when you, let's say, get replaced. So it quickly adds up if you do not respond to people.
Ladies, I want to thank you both again, Marguerite DeVoe and Shakrisha DiBartolo from the law firm of Watt, Teeter, Hoffer, and Fitzgerald, for, again, taking the time to come back and visit with us on the Probate Nation to share with our viewers your extensive knowledge, advice, and experiences on the enforcement of surety bonds. You know, really, again, valuable information for executors and conservators, and really a great public service to the Northern Virginia community. So thank you again for taking the time.
All right. So Probate Nation. Again, Probate Nation right here on YouTube. It's an older video, but I thought there were a couple good ones last week and this week. And like I said, I think it's correlating the same way I see things in being able to instrumentalize the documentation by knowing the languages so that you can negotiate them as vessels to the right port. You're literally going to take on that merchant mariner sense thing of being the captain of the vessel by knowing which vessel it needs to be salvaged and whose it is, so you can claim the salvage rights. It's technically a vessel of the United States in special maritime territorial jurisdictions under obligations and other securities of the United States, which includes all bonds. So think about this stuff, folks, and I'll be back again. I've got some information kind of stacking up here, and I don't want to do this, have it long and drawn out. I've got the IRS meeting coming up here in a couple of weeks or so, and so I might come back tomorrow and do my 9 o'clock streams on some of this stuff and build up for that IRS. I want to get back to the contractual indemnification of government contractors, so we can see what that brings about as far as maybe showing us the same correlation that I'm trying to put forth. We're dealing with government indemnification contracts. So we'll take a look at that. What else? Oh yeah, indemnification under 10 U.S.C. 3861. So those would be the next two things I want to look at and see if they correlate again with the indemnification process I'm looking at with the SEC and having them certify it as an indemnification agreement across the board for double whatever anybody else has got. The one guy we saw there, John A. Williams Trust, he had one on there for $100 billion certified by the SEC. So evidently there was 4 of them he was talking about specifically. So again, it's not a matter of cost, it's a matter of financing, which is settlement, putting into, do it today. Get into your research so you can learn how to put forth this document and get it settled for now. Quit deferring the debts, quit believing that you have to keep making these promises, and learn how to operate your daily life in good faith with everything you do. And just like Socratic logic, it will affect every corner of your life if you can do that. And that brings us to the end of our stream. And I want to thank everybody for your support. Please hit that like, share, and subscribe button. There's a PayPal link out down there for anybody that wants to share some love. Every little bit is appreciated at all times. Please help out. And then, of course, you guys know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see you next time.